was, I don't think that, unfortunately, is something that we have to advise people, but we should not be saying to people, when an officer kindly asks you to do something or gives you a friendly reminder, you just do it or it's going to turn out bad for you. That's not the kind of place that we're supposed to live in. It's okay for people to know their rights. You don't even have to take a bar exam in every state in this country to be a lawyer. You don't have to go to law school in every state. Law is still done in some places through learning and apprenticeship. There are smart people who study and learn the law. There are quote-unquote jailhouse lawyers that could go toe-to-toe with any of us in this courtroom today. I do not find that Mr. Pletz interfered with traffic. I do not find that Mr. Pletz disobeyed the lawful order of a police officer, just so it's clear. I believe that Mr. Pletz's actions fell within the exception of the statute, rendering the order for him to return to the bike lane unlawful. I do not believe that there is a violation here. My finding is not guilty.
This also involved ID refusal.
Thank you, Your Honor.
Michigan.
Thank you, counsel. Thank you, Sergeant.
All right. You guys have a good. Thank you, Sergeant. You guys have a great day.
Okay, you too.
The judge found Pletz not guilty on both counts, ruling that his actions fell within the statutory exception that allows a cyclist to leave the bike lane when obstructions make it impractical or unsafe to remain.
Of course, this being particular.
Under Michigan law, Michigan Vehicle Code, Section 2, 57.660A, a cyclist riding slower than traffic must stay as close as practicable to the right edge of the road, except when conditions make that unsafe or unreasonable. The judge found that the construction zone on 4th Street met that exception, and that the order directing Pletz back into an obstructed lane was therefore not a lawful order. Without a lawful order, there was no legal requirement for Pletz to identify himself, and no basis for either charge. The ruling also carried a broader point that the judge put on the record directly. Knowing your rights is not the same as being difficult, and an officer asking you to do something does not make it lawful simply because the request came from a badge. If you think the officer had the right to give that order regardless of the
just because they're investigating something or claiming to investigate something, they're supposed to do a proper investigation that nets facts that constitute reasonable articulable suspicion of an articulable crime that is a statute violation, that they can summarize, all the facts as to what crime they actually suspect and why they suspect you of it, to compel you to surrender your identification, which is technically a violation of the Fourth Amendment, but because if they suspect you of a crime and have the proper, what they need, the proper, threshold, meet the threshold, in this case being RAS. Now, I'm not confusing that with preponderance of evidence or probable cause or beyond a reasonable doubt. Okay, I know what reasonable articulable suspicion is, and that it has to be of a crime, especially if you're not being pulled over and it's not a traffic stop and you're not in a moving vehicle. And no, I wasn't sitting on my ID. I had it in my lap because I had it ready to go in the bank. And then when the cops came up to me, I also had it ready to hand to them if they were to have any freaking reasonable reason to compel it from me. And knowing your rights is not a wrong, bad thing. It doesn't go well for you.